Nobody invited Jonathan Dukes into that house. Certainly not Richard Loud. And that, folks, constitutes a trespass. We know the residence. We know where it is. And it's an occupied structure. We've proven to you that Richard Lowther lives there. You know that. When another person was present, another person is indeed Richard Lowther. He told you he was present. Jim Oakes told you that Richard was present. Jetty Fetty told you he was present. And Jonathan Dukes said he was there when he went in the house, with purpose to commit therein a criminal offense. The judge is going to define purpose to you, but use your common sense. How do you determine what somebody's thinking on that purpose? How do you determine what Jonathan Dukes had in mind for that purpose element? It's simple. You look to all the other factors. You know they had a discussion of what they were going to do. You know they talked about getting into that house, stealing $50,000, taking the safe. We all know that. That was the purpose. That was the purpose. Proof for that element has been met. Purpose there to commit a criminal offense. We know it was a criminal offense. It's a theft. It's a burglary. And that Jonathan Dukes or one of his companions recklessly inflicted or attempted or threatened to inflict physical harm on Richard Lowther. You'll recall my arguments as to recklessness with regard to the charge of aggravated robbery, and I would say to you that those same arguments apply here. When you know your target's an elderly person and you're going to use force, you can pretty much assume something bad is going to happen, and that, ladies and gentlemen, is reckless. Physical harm, because recklessly inflicted or attempted to inflict physical harm. Difference between that and aggravated robbery. Aggravated robbery requires serious physical harm. Here you only need physical harm. What is it? It's any injury, illness, or other physiologic impairment, regardless of its gravity or duration. Doesn't have to be serious at all. It can simply be impairing someone in a physiological manner. So let's say you sit on their chest and cover their mouth. They're impaired from breathing. Can't breathe real well. That's a physiological impairment. So if you find Jonathan Dukes didn't do anything with that, that's sufficient. Doesn't matter for how long. Could have been a second, could have been a minute. Regardless of duration, it says. Again, if you decide that Jonathan Dukes here was not the person that inflicted serious physical harm on Richard Lowther, then, ladies and gentlemen, I submit to you that he was complicit and did aid and abet in that and is as guilty at the same level of the offenses charged as anyone else. Count one, of course, is murder. We commonly call that felony murder. You've heard me say that here. Remember this. We talked in voir dire. The state of Ohio doesn't have to prove prior calculation of design, intent, or motive. It's not needed. Not for the murder of Richard Lowther. They needn't prove, the state of Ohio doesn't have to prove that Jonathan or anyone else went into Richard Lowther's house in order to kill him that night. Don't lose sight of that. It's a false argument. It's not part of the elements of felony murder. What are is this, that Jonathan H. Dukes, on or about July the 30th, 2009, we use July the 30th because that's the date that Richard Lowther ceased to be a living person. That's when he died. But we know that the injuries that caused that were inflicted on July the 2nd, 2009. Caused the death of Richard Lowther. Cause is an act which in the natural and continuous sequence directly produces the death of Richard A. Lowther, and without which it would not have occurred. So, what do we know? We know that Richard Lowther received an injury of such a nature and extent that his body was starting to shut down almost immediately. You know that when Michael Lee got on that back porch and he was testing him, working from the bottom up as he described it, no feeling in his toes at that point, no feeling in his legs at that point, no feeling in his hips at that point, some in his abdomen at that point. But you also know from Michael Lee that as they transported Richard to the hospital, he began losing feeling in the abdominal area and in his lower torso. To the point where it got to the point where from his nipples down, Richard Lowther was no longer a functioning human being. Regardless of what you heard from the defense expert, ladies and gentlemen, that's what killed Richard Lowther. It wasn't taking him off a ventilator, off a machine. That didn't kill him. You gotta ask yourself why he was there. Think about this. The only person of a medical nature that did a physical examination of the body of Richard Lowther after he passed away was Dr. Dorothy Dean. Dr. Dean is a licensed medical examiner in the state of Ohio. She, ladies and gentlemen, she alone in this case, has the ability to pronounce the cause and manner of death. And when you get back in that courtroom, take a look at the death certificate, which is here somewhere. And on that death certificate, you're going to see a line that talks about, thank you. It talks about the immediate cause of the death. And you're going to see that Dr. Dean has made a finding. And the immediate cause is complications of spinal cord injury. She then goes on to say that that is due to blunt force trauma to the neck. He didn't get blunt force trauma to the neck from being on a ventilator, ladies and gentlemen. That's not what caused that spinal cord injury. That's not what put Richard Lowther in the condition he was in. I would submit to you that if it hadn't been for the reaction of the EMTs and the medical people at Robinson Memorial Hospital and later those at Akron City, that Richard Lowther, if you'll pardon my expression here, would have been in the morgue with a toe tag on that night. That night. As approximate result, use your common sense, approximate merely means it's something that's imminent or something that's near in time. As approximate result of committing or attempting to commit an offense of violence. An offense of violence. That's singular. It's singular. And that offense of violence is a felony of either the first or second degree. Okay. We go back to the aggravated burglary and aggravated robbery, and that's why they went to Richard's house. Those are both, ladies and gentlemen, as defined by the Ohio Revised Code. Those are felonies that are of a violent nature. They are first degree felonies. Recall that I had talked to you earlier about the underlying felonies that the state has to prove in connection with the murder charge. And those were felonious assault, that was aggravated robbery, or aggravated burglary. And you have to read that with an or in between because you only need to find one of those existed in this case. If you find more, that's fine. You look at them all. You look at them all. We haven't talked much about felonious assault, but ladies and gentlemen, the elements of that would be that on or about July the 2nd of 2009, Jonathan Dukes here knowingly caused serious physical harm to Richard Lowther. And we know that happened. And so there's no confusion, even as to those underlying charges. Complicity still applies. If he aided or abetted someone else who committed that act, he's still guilty of that as well.
You've used 30 minutes, Mr.
Thank you, Your Honor. Just be another second here. So, ladies and gentlemen, the state of Ohio has presented you with the evidence in this case. It's unchallenged. It's uncontroverted. And, at least in part, it's admitted by the defendant, Jonathan Dukes.